Breaking news tonight from Washington. The Epstein files have been released, or have they? In a stunning development that's raising more questions than answers, the Department of Justice has posted what they're calling the Epstein files to their official website. But legal experts, congressional Democrats, and transparency advocates are crying foul, calling this nothing more than a carefully orchestrated cover-up disguised as compliance. What we're witnessing isn't transparency, it's strategic concealment. The Epstein Transparency Act became law with overwhelming bipartisan support. 427 votes in the House, a unanimous 100-0 in the Senate. 3 federal judges have issued explicit orders demanding full disclosure. The deadline was clear. The requirements were unambiguous. And yet, what was delivered falls dramatically short of what was legally mandated. Documents that were supposed to be released in their entirety are heavily redacted. Names that congressional sources say appear throughout the original files are mysteriously absent from the public version. Search functions on the DOJ website return 0 results for individuals known to be connected to the case. This isn't an administrative oversight. This is deliberate obstruction. One Democratic congressman has drawn a line in the sand, warning that anyone involved in concealing these documents will face criminal prosecution, not political consequences, not strongly worded letters, actual federal charges for obstruction of justice. The stakes have never been higher. The implications stretch from the Department of Justice all the way to the Oval Office. And the questions being asked are ones that could define the remainder of this administration. Before we examine what was released and what remains hidden, let's hear directly from the lawmaker who's promising accountability for those responsible for this alleged cover-up.
Tomorrow at midnight is the deadline for Pam Bondi to release the Epstein files. That is what Thomas Massie and my bill calls for. It passed this body 427-1, passed the Senate 100-0, and the president signed it. Now, 3 federal judges have ordered the release of all of these files in Maxwell and Epstein's grand jury. Here is the reality. Any Justice Department official who does not comply with this law will be subject to prosecution for obstruction of justice. If Pam Bondi does not comply with the law, she will be held either in inherent contempt of Congress or subject to impeachment. We will not rest until the law is complied with and justice is served. Thank you.
That statement represents a watershed moment in congressional oversight. No equivocation, no diplomatic hedging. Just a straightforward promise. Defy this law and you will be prosecuted. The message extends beyond the Attorney General herself. It reaches every DOJ official, every staffer, every person who touched these files during the redaction process. The warning is clear. Complicity carries consequences. This isn't partisan politics. This is about the rule of law and whether it applies equally to everyone, regardless of position or power. What makes this particularly explosive is what's happening behind the scenes. According to multiple sources, the Department of Justice reportedly authorized tens of millions of dollars in overtime pay. Some estimates suggest upwards of $80 million to bring in additional FBI personnel specifically to handle the redaction process. Think about what that implies. If the files contain nothing problematic, why would such extraordinary measures be necessary? Why call in reinforcements? Why spend astronomical sums to carefully comb through every page? The scale of the redaction effort itself suggests there's something significant being concealed. And then there's the president's behavior. In what can only be described as a bizarre press appearance, he refused to take questions about the Epstein files, claiming doing so would somehow soil the event he was holding. His discomfort was palpable. His evasiveness was telling. For someone who typically relishes confrontation and rarely shies away from media battles, this sudden reluctance speaks volumes. Let's look at that moment.
All in the insurance companies that are making so much money and they have to make less, a lot less. And maybe we can have reasonable health care without having to cut them out and let it all go awry. So we're going to be calling a meeting. It'll be either in Florida or it'll be here the first week. And I'd prefer not talking and asking questions only for the reason that this is such a big announcement, meaning what these people have said and what the other four companies are going to say, which is exactly the same thing, that I really don't want to soil it up by asking questions, even questions that are very fair questions that I'd love to answer. So I think we have to just stop right here.
That's not the demeanor of someone with nothing to hide. That's someone who understands the ground is shifting beneath him. Political analysts are noting something remarkable. Even members of his own party who've defended him through countless controversies are drawing a line here. The base is restless. Conservative media figures who typically provide cover are asking uncomfortable questions. Congressional Republicans who rubber-stamped previous actions are suddenly demanding answers. This issue transcends typical partisan divisions because it touches on fundamental questions of justice and accountability that resonate across the political spectrum. When the announcement came this morning from Deputy Attorney General Todd Blanche that the complete Epstein files would not be released as ordered, it confirmed
Epstein
what
himself
many
was not
had
seen as a
suspected.
drinker, and the report
But
in
what
the Times
actually
does
was
not
posted proved even more revealing than the omissions. A prominent political commentator attempted to search the DOJ's Epstein files database for specific names that congressional sources say appear throughout the original documents. The result? 0 matches. Not a single reference. Yet we know from multiple independent sources, members of Congress who've reviewed the unredacted files, investigative journalists who've obtained related documents, and even administration officials who've accidentally let information slip, that certain names appear repeatedly throughout the case materials. How do you release files while simultaneously ensuring specific individuals cannot be found within them? That's not transparency. That's concealment with a veneer of compliance. Here's what makes this particularly damning. The administration's own chief of staff has reportedly acknowledged that certain names appear in the files. The Attorney General was briefed on the contents. Congressional members from both parties confirmed what's in there after being given access. So, when the public version comes out scrubbed clean, it's not a matter of interpretation. It's documented evidence of deliberate alteration. Every person involved in that process, from the senior officials who authorized it to the staffers who executed it, has now participated in what legal experts are calling a clear violation of federal law. The court orders were explicit. The statutory requirements were unambiguous, and they were deliberately ignored. The question isn't whether a crime was committed. The question is whether anyone will face consequences for it. And that brings us to a broader issue about what we already know versus what's still being hidden. Even without the complete files, independent reporting has uncovered disturbing connections and patterns of behavior that would be disqualifying for any public official. Recent investigative journalism revealed that, according to a former family member's testimony, a mother was warned to keep her 14-year-old daughter away from certain individuals due to safety concerns. That revelation alone would have been the defining scandal of any previous presidency. We've learned about birthday cards referencing secrets and women. We've seen photographs documenting relationships that were later denied. We've heard testimony from employees describing inappropriate behavior and concerning patterns. And that's just what's publicly available through traditional journalism and civil lawsuits. That's the information that exists outside government control, beyond the reach of DOJ redaction pens. If material that's already public is this damaging, imagine what's in the files that 3 federal judges ordered released. Imagine what required $80 million worth of overtime to conceal. Imagine what has the president too afraid to take questions. As of December 2025, legal experts are debating whether the partial release and extensive redactions could trigger contempt proceedings or additional court challenges, with some suggesting that the redaction process itself may become the subject of congressional investigation. The pattern we're seeing isn't speculation or conspiracy theory. Every prediction critics made has proven accurate. They said there would be attempts to delay. There were. They said the release would be incomplete. It is. They said certain names would be scrubbed from the public version. They have been. At what point do we stop calling these conspiracy theories and start calling them documented facts? The absurdity of the situation is highlighted by recent events. The FBI, with its $10 billion annual budget and thousands of agents, couldn't accomplish basic investigative work that Internet users on public forums managed to figure out. The same agency that's supposed to protect these files couldn't locate information that amateur researchers found in hours. Either they're incompetent or they're complicit. Neither option inspires confidence. This is why continued public pressure matters. This is why asking questions isn't just appropriate, it's essential. Because every time critics raised concerns about this case, those concerns were validated. The birthday book people said couldn't be real, it was real. The close personal friendship that was denied, documented in contemporaneous records. The preferential legal treatment for co-conspirators. It happened exactly as predicted. So when observers look at heavily redacted files and suspect there's more being hidden, that's not paranoia. That's pattern recognition based on consistent behavior. We need to examine what independent journalism has continued to uncover, because these revelations exist outside the government's ability to suppress them. Court testimony, employee accounts, and investigative reporting are building a picture that the redacted files can't erase.
Have reinforced how the two men socialized. Some of that, of course, was known well before this article. The assistant indicating Trump seemed to enjoy regaling Epstein with tales of his sexual exploits. Epstein seemed to delight in how uncomfortable it made his assistant to overhear them or have to hear them if that was part of the job. Another Epstein employee said, quote, Trump would occasionally send over modeling cards for Epstein to peruse like a menu, raising questions about who knew what was the intention with those so-called cards. Now, the article has accounts of Epstein arranging for underage models to come socialize with adults, mentions parties where they were illegally offered alcohol. Epstein himself was not seen as a drinker, and the report in the Times does not accuse Trump of involvement in Epstein's crimes. It also notes that the women quoted in the new article did not accuse Trump of unlawful actions. And that's important to note. You have to look at all the facts, reporting, and allegations. And in a period of major allegations, some proven against Epstein, the fact that the Times talked to people who did not accuse Trump is relevant if you want the whole context of that story. That is the reporting that refers to some of the women, as well as perhaps underage women, that were in Epstein's circle or recruited for it at the time. But while that's the Times article, we can also note in context other women have accused Trump of improper conduct, including E. Jean Carroll, who won 2 civil judgments, ultimately over $80 million, upheld by an appeals court. I can tell you the United States Supreme Court is currently considering whether to hear that appeal, which would be Trump's last chance to potentially change or interfere with it. But as of this hour, under our courts of law, including the appeals court, they found Carroll to be the winner. And there are other accounts that you've probably heard of regarding allegations against Donald Trump. So you have the allegations and questions swirling over all of this. Some remain about Trump personally, but we can go well beyond his own personal liability in the Trump-Epstein relationship, which you see here. There's the broader case timeline, and the documents due tomorrow can shine light on Epstein's long history evading justice, which we've been charting. So that could implicate Donald Trump not only with what he did or didn't do in the 90s, and whether it's embarrassing or not or worse, but what he has done recently overseeing his DOJ and cabinet.
That reporting represents the kind of information that exists beyond government control. Employment records, witness testimony, civil court proceedings, these create a documentary trail that can't be redacted by the Department of Justice. The significance goes beyond embarrassing revelations about past behavior. It extends to recent actions, specifically how this administration has handled the case since taking office. If there's evidence of a cover-up, that's not historical misconduct. That's current, ongoing criminal activity, obstruction of justice, tampering with evidence, abuse of power. These aren't abstract legal concepts. They're federal crimes with serious penalties. The question of personal liability from decades ago is one issue. The question of current obstruction is another entirely. And the second one has immediate legal consequences. What we're witnessing is an administration that believed it could simply ignore court orders and face no repercussions. They calculated that partisan divisions would protect them, that public attention would fade, that nobody would actually follow through on accountability. They may have miscalculated. Congressional Democrats are no longer issuing warnings. They're making promises, prosecution, impeachment, contempt proceedings. These aren't threats to be negotiated away. They're legal mechanisms being prepared for deployment. Every person who participated in the redaction process, every official who signed off on non-compliance, every staffer who helped conceal court-ordered documents, they're all now on record as having violated federal law. And the paper trail exists. Emails coordinating the redactions, memos authorizing the overtime, meeting minutes discussing strategy. All of it is preserved and subject to congressional subpoena. The administration may control what files get released to the public, but they don't control congressional oversight powers. They don't control civil lawsuits. They don't control investigative journalism. And they don't control the historical record. What's particularly striking is how this issue has broken through typical partisan filters. This isn't about tax policy or regulatory philosophy. This is about whether powerful people face the same legal system as everyone else. When one co-conspirator in the case is reportedly serving time under conditions that bear little resemblance to typical federal incarceration, with amenities and privileges that mock the concept of punishment, it sends a message about two-tiered justice that resonates with people across the political spectrum. The American people understand that something is fundamentally wrong when court orders can be ignored, when files can be concealed, when accountability seems to stop at a certain level of wealth and power. This moment is a test of whether our institutions can function as designed, even when that's politically inconvenient for those in power. The complete files will eventually come out, perhaps through congressional investigation, perhaps through lawsuits, perhaps through whistleblowers who decide their conscience matters more than their career. History shows that cover-ups rarely succeed in the long term. The truth has a way of emerging, often in the most damaging way possible for those who tried to conceal it. What happens next depends on whether congressional oversight has teeth, whether the judicial system can enforce its own orders, and whether public pressure remains focused on demanding accountability. One thing is certain, this story is far from over. The partial release and obvious redactions have only intensified scrutiny. The refusal to comply with court orders has created new legal jeopardy for everyone involved. And the American people are watching to see whether justice applies equally to everyone or whether some really are above the law. The documents that were released raise more questions than they answer. The names that are missing speak louder than the ones that remain. And the extraordinary effort to conceal certain information tells us more than what was actually shared. This is a defining moment for accountability in American democracy. Either our institutions respond to clear violations of law, or they demonstrate that power provides immunity. The choice before Congress is straightforward. Enforce the law they passed with overwhelming bipartisan support, or accept that court orders and statutory requirements are merely suggestions for the politically connected. As this situation develops in the coming days and weeks, one principle should guide the response. Equal justice under law means exactly that. No exceptions for position. No special treatment for power. No immunity for those who believe they're untouchable. The Epstein files may be partially hidden for now, but the cover-up itself has been fully exposed, and that may prove to be the most damaging revelation of all. We'll continue following this story as it unfolds, because ultimately it's about more than one case or one set of files. It's about whether our democracy can hold powerful people accountable, even when they control the levers of government. The answer to that question will define this moment in American history.